You know, it's a story so many of us can probably relate to, right? A simple neighborhood disagreement that just spirals into something way bigger. But here's the thing. This isn't just some made-up story. It's a real legal case, and it shows exactly what can happen when a homeowner's peace gets totally disrupted and their HOA, well, they just won't listen. So let's dive right into the case of Kirby versus the Cove Estates Homeowners Association.
Just listen to this for a second. This one sentence, pulled straight from the actual case file, it gets right to the heart of the whole thing. See, this was never just about some trees. It was about feeling heard, about being respected, and getting treated fairly in the very community you pay good money to be a part of. And that feeling? That's what pushed Rodney and Patricia Kirby to take on their own HOA. All right, so to really get what's going on here, we first have to understand the people at the very center of this storm. So let's meet the Kirbys and find out why their backyard meant so much to them.
Okay, so picture this. Rodney and Patricia Kirby. They'd been living in their Cove Estates home for 17 years. They're retired, getting on in their years, and for them, that backyard pool, it wasn't just for fun. It was literally a vital part of their daily exercise. And these weren't people who just hired everything out. They were really hands-on, taking care of their own pool, their own landscaping. For them, that backyard was their sanctuary.
Now, every story has that one thing, right? The source of all the trouble. And in this case, it started really small, just two little saplings planted on the HOA's common property. But as you're about to see, over time, those little saplings grew to cast a very long shadow over the Kirbys' lives.
So when the Kirbys first bought their house, these two sissoo trees were nothing, just tiny saplings. They were planted up on a hill in the HOA common area, maybe 5 feet away from the Kirbys' retaining wall. For years and years, you probably wouldn't have even noticed them.
But oh boy, fast forward to when this whole thing finally got to a hearing. Those saplings, yeah, they weren't small anymore. We're talking 35-foot-tall trees just towering over the Kirbys' property. They had become a problem that was absolutely impossible to ignore.
And what's really wild here is just how long this whole problem was left to fester. I mean, think about this timeline. The trees really start becoming a nuisance around 2014. That's a full 10 years after the Kirbys moved in. They start formally complaining in 2017, but it still takes another 4 years of escalating frustration before it finally lands in a hearing in 2021. This wasn't some sudden blow-up, it was a really, really slow burn. And the damage, it was very, very real. I mean, we're talking about a constant barrage of debris, not just leaves, but even small dead animals dropping into their pool. It was so bad it clogged and broke their pool pump, not once, but multiple times. The roots started threatening their retaining wall and their patio. And then, to add insult to injury, the whole COVID-19 chlorine shortage hit, which meant their cost to keep the pool even usable just skyrocketed. This was a huge financial and personal burden.
Okay, so this is where we get to the core of the conflict, the real showdown. You've got the Kirbys, who see a direct threat to their property and their well-being, and then you have the HOA, which, well, they saw the whole thing through a completely different lens. Let's break down their arguments. So the Kirbys' argument was pretty straightforward. They were essentially saying, hey, your trees are on common property, sure, but they're causing real damage to our private property. It's costing us money, it's a potential health risk, and you have a duty to fix it. But the HOA's defense was, in their minds, just as simple. They said, look, we hired a professional landscaping company, ProQuell. Our expert arborist checked out the trees and didn't recommend removal. We did what our expert told us to do, so we've done our job. And really, this one detail just perfectly sums up the HOA's entire position. Their policy was completely rigid. If we don't get a written recommendation from our expert to remove a tree, we're not removing it, period. End of story. They basically outsourced their entire decision-making process to their contractor, ProQuell, and in doing so, they built this procedural wall that the Kirbys just kept running into.
So, with neither side willing to budge an inch, this whole thing finally lands in an administrative hearing on September 22, 2021. This was it. This is where both the Kirbys and the HOA were going to make their final stand.
In their closing arguments, the HOA basically just doubled down on their main point. Hey, we relied on our experts' advice, the trees are on a regular trimming schedule, so we are not in violation of the rules. It was all very procedural. But the Kirbys' closing argument? It was deeply, deeply personal. They talked about how their health and welfare were at risk. They pointed out that the HOA never once bothered to even come look at the damage from their property. And instead of getting any help, the only response they ever got was a threatening letter from the HOA's lawyers.
Okay, so after hearing from both sides, it was all up to the administrative law judge. A decision had to be made. So how did the judge weigh this? You've got the HOA's by-the-book, procedural defense on one side, and the Kirby's very real, tangible evidence of harm on the other. Let's break down how it all went down.
First, we got to talk about the legal standard here, because it's super important. The Kirbys had what's called the burden of proof. They had to prove their case by a preponderance of the evidence. Now that sounds like a fancy legal term, but it basically just means they had to convince the judge that their claim was more probably true than not. Think of it like tipping the scales. It's not like a criminal case where you need beyond a reasonable doubt. You just have to tip the scales, even just slightly, past that 50% mark.
So here's the million-dollar question, right? Did all of the Kirby's evidence, the clogged pumps, the endless debris, the financial records, the photos of the damage, did all of that manage to clear that bar? Was their story more probably true than not? And the answer? A clear, resounding yes. The judge found that the Kirbys had absolutely sustained their burden of proof. They did it. They proved their case. But the reason why they won? Now that is the most important part of this whole story.
And here it is. This one quote from the judge's decision is the absolute key takeaway from this entire case. The association's duty to maintain the common area does not end at the boundary line of the common area. Let that sink in. The judge basically said, yeah, the trees are on your property, but the damage they're causing is crossing the property line. And if the damage crosses the line, so does your responsibility.
So the Kirbys won. Huge victory. But what did winning actually look like in practice? The judge's final order laid out some very specific results, but it also came with one really important limitation. First off, their petition was officially granted. So, check, they won the case. And second, the HOA was ordered to pay them back their $500 filing fee within 30 days. So this was a clear win for the homeowners, both legally and financially. But, and this is a really important but, here's the crucial nuance. The judge's decision made it very clear that the court did not have the power to just order the HOA to go chop down the trees. The court's authority was limited. All it could do was order the HOA to follow its own maintenance rules. So, while the Kirbys won the argument that the HOA was failing in its duty, the court couldn't tell them exactly how to fix it. And so, this case leaves us with this really fascinating question, one that applies to millions of us who live in HOAs or other planned communities. The judge made it clear. An association's responsibility doesn't just stop at a property line on a map. But if that's true, it really makes you wonder, doesn't it? How far does that responsibility actually extend? That's something for every single homeowner and every single HOA board member to think about.